Thank you, Donald. And before I get started, I just want to thank Donald and his team for putting together this conference and just more generally all of the fabulous programming that the Law and Economics Center hosts for both judges and staff of attorneys general offices. I have benefited tremendously from those over the past few years, and I know we all feel the same way about that. So thank you, Donald. We have a very distinguished panel this morning to kick off this program. And without further ado, we'll dive right in. I'm going to start by giving brief introductions of the panelists, and then each panelist will give about 10 to 12 minutes of opening remarks, and then we'll have some exchange among the panelists, and then we'll move to audience questions. So to my far left is Professor Catherine Sharkey. Professor Sharkey is the Segal Family Professor of Regulatory Law and Policy at NYU School of Law. She's one of the nation's leading authorities on the economic loss rule, punitive damages, and federal preemption. The rest of her impressive bio is in your material, so I encourage you to take a look at that. And then next we have Professor Ellie Bublick. She is the Dan B. Dobbs Professor of Law at the University of Arizona James E. Rogers College of Law. She's the co-author of the leading U.S. tort law treatise and Hornbook, The Law of Torts and Hornbook on Torts. Next, we have Professor Shelley Ross Saxer. She is the Laure Sudreau and Endowed Professor of Law at Pepperdine Caruso School of Law. She clerked on a federal district court and worked briefly at Century City Law offices of O'Melveny and Myers. She's also the co-author of many legal textbooks for a variety of subjects. And then to my immediate left is Victor Schwartz, who is currently the co-chair of the Public Policy Practice Group at Shook, Hardy & Bacon, L.L.P. Before moving to that position, Mr. Schwartz was a professor and dean at the University of Cincinnati College of Law, where he currently serves on the college's Board of Visitors. And I also learned what is not in his bio is he's the co-author of Prosser and Keeton on Tort, which just sold its 1 millionth copy. Impressive. And with that, so we are going to do the presentations in alphabetical order. So I will let Professor Bublick kick things off.
And then you should be down there. The presentation.
Which one? This one? We got it. Perfect. Thank you so much. It is such a pleasure to be here, and we all appreciate the great work of Professor Koshan and all of the Law and Economics Center in bringing us here. I want to talk today about the subject of public nuisance, particularly tort actions for public nuisance. So as we're thinking today about all these important questions that we have with respect to opioid cases and greenhouse gas cases, and even thinking about what the law should be in terms of writing the fourth restatement on public nuisance, I think it's always helpful to go back and to look at the enduring principles that we have already with us from so many past cases. And it's just been a lot of fun reading cases about floating logs down a river, and when utility poles were being put up in the middle of the streets, and there are a lot of really interesting historic cases. So today I'm going to talk to you about 3 different things. The first is, what are private actions for public nuisance? We all hear a lot about the public actions, but what are the private actions? The second is, are these private actions for public nuisance new? And the third is, what function do these actions serve? So I'm going to start with the doctrine. I'm a treatise writer, and so that's where I like to start. And I just want to let you know that the Hornbook on torts is available through the materials for this program, and the treatise is also available in Westlaw. So I'm going to start with common law nuisance claims. There are also statutory claims that I'm sure we'll hear about a lot over the next few days. But the common law claims for nuisance take two varieties. One is private nuisance claims, and the second is public nuisance claims. So in the private nuisance claims, one thing that's interesting about these claims is that they really emphasize the type of harm suffered by the plaintiff. And requirements for the tort are substantial and unreasonable interference. And here the interference is with a right to use and enjoy property. So these are non-trespassory invasions that a landowner should not be expected to bear without compensation. There's tangible harm, there's diminution in value, there's personal discomfort. So examples might be something like noise or odors or pollution, and we'll see some more examples. The public nuisance side, a lot of these same requirements prevail. So there's, again, an emphasis on the type of harm to the plaintiff. There's also substantial and unreasonable interference. And one of the key differentiating factors is this last part, that it has to be a right held in common by the general public. And this can be a whole range of things, obstructions of roads and waterways, and different kinds of actions that can affect physical, emotional, and economic harms. Within the public nuisance space, so now just looking at the right half of that former slide, we have two different kinds of enforcers. The first is public actions. So all of you in the AG's offices are familiar with this. Public authorities can bring suits most frequently for injunctions or for abatement, and there's some question now about damages. Private actions are brought by individuals in civil suits, and these can also be for injunction or abatement, and clearly these can be for damages. So some of the requirements for the damage suits, the private plaintiff has to show some kind of special damage or special injury in the exercise of a public right, and it has to differ in kind from harm suffered by the general public. So just putting these together, let me just give you one example that invokes all three of these areas. So let's suppose defendant is dumping sewage in a stream. First, we can have a public action for the public nuisance. So I'm hoping all of you out there in the AG's office are thinking, you know, we should bring an action to enjoin the dumping and to abate whatever damage was done by it. Private actions for private nuisance, a landowner, let's say that the stream goes, abuts their property, might say, you know, there's odor, there's a diminution in land value. I can't rent the property, I can't sell the property, it's not worth what it was, and they can have a private action for a private nuisance. But this hybrid category where a private person brings an action on the public nuisance, you have to show some kind of special injury. So what would be an example of that kind of special injury? In this case, there were animals who were drinking from that polluted stream who were harmed, and so that can be the special injury. If people were harmed, that could be the special injury for an action. I've been looking at some of the cases in Tennessee, and they're all really interesting. Just going to bring one to your attention. There's a tradition of cases of houses of ill fame and how that adversely affects conditions, houses of prostitution. And so you might see a number of different actions, and the Tennessee court in this case said that someone who just rents out properties near this disruption could recover. And in that case, the Tennessee Supreme Court sort of outlined, look, we do have all these criminal actions that are available, but also we have civil actions that are available. And not only can we have abating the nuisance and injunctions, but also in modern times, the modern time of 1899, we also have these remedies that courts grant, and in particular, that court granted damages to the individual. So pulling an 1885 treatise that was cited by the Tennessee Supreme Court, you can see right from the beginning of this section, in general, an individual may recover for special damages for an injury which is itself a nuisance. So these actions have existed for quite a long time, and in fact, there are pages and pages in the treatise about what kinds of things constitute a nuisance, and documenting cases about when individuals could bring claims for special injury. The first restatement of torts is very consistent with these treatises. It says a private action may, however, arise out of a public nuisance, and as such must be distinguished from private nuisance. So again, there are those two different categories, not just all private nuisances, but private actions on a public nuisance. The second restatement of torts has, under the leadership of Dean Prosser, a whole section on private actions for public nuisance and what they require. And the requirements are very, very stable over at least the 150 years that we've been able to look at. So what I want to talk about a little is the case law. So what, at a previous Law and Economics Center conference, one of the things that came to our attention is that a lot of discussion is happening about these cases. They're new, or Dean Prosser invented them out of nothing, or different kinds of claims that are made. And there isn't a lot about the history of these cases. So one of the things that Professor Sharkey and I are trying to do is to create really a database of all the early cases. Just what are those private actions for public nuisance? The biggest difficulty is that there are thousands of cases. They're great to read, they're so interesting, but there are thousands of them. So let me just give you a little sampling here. And I took every 25 years, just some Westlaw searches and some key number searches to see, what are we talking about in terms of time. And as you can see, there have been a lot, and they have, historically there were many declined, and now seems to be a resurgent. What's the function that these private actions for public nuisance serve? And I think the most important function that I want to leave you with is these are the rights of people who are harmed by the public nuisance, but don't necessarily have an interest in land. So sometimes these can just be impairments of use and enjoyment of property of people who are not owners of land. There are several mobile home cases, renter cases, and so on. But most importantly, these can be physical interests in property. So if you have physical ailments from a landfill, sometimes these are emotional. You see that in the House of Ill Fame cases, but some modern cases with private zoos, and then economic harms, which I know some of my colleagues will talk about at greater length. Thank you so much.
Thank you, Professor Bublick. And now we'll hear from Professor Saxer.
Thank you. It's pretty unusual to go second alphabetically for me, Anyway, welcome to all of you. I am hoping to get some feedback from you. I'm talking about a more narrow area of public nuisance, and that has to do with state action. And so I have struggled trying to understand over time, when does state action apply? Does it apply anytime court enforces a private right or a public right? And so with this, I have looked at, if you're talking about speech torts, so this is the problem I'm trying to address. When you look at speech torts, you see New York Times versus Sullivan, and then the most recent case that caught my attention was Snyder versus Phelps. That was the situation with the Westboro Baptist protesters at a veteran's funeral, and the parents brought an emotional distress claim that the jury awarded them damages, but it was overturned. And my thought was, how can that be if we have two private individuals? And the Supreme Court doesn't even talk about state action and where that's coming from. So then I started looking in other areas, and I find that in contracts, things like arbitration settlements are not considered to be state action. In other words, if there are, the biggest reason for me looking at state action is being concerned about constitutional claims. When can you make a constitutional claim if there is state action and private parties? And so with contracts, we also see that homeowner association, whether you look at that as contract or property, those private covenants we saw in the case of Shelley versus Kramer regarding racially restrictive covenants, that the Supreme Court found state action by the enforcement of those covenants. That was really not extended beyond racially restrictive covenants. And so you find that with homeowner association rules, unless you're in a state like New Jersey, there is not considered to be state action. So if you're a resident and you've put up a flag, you cannot defend based upon the First Amendment against a private action. Then we get to property law, and looking at trespass, the Alabama versus Marsh case initially held, well, it was a company town, so that's been used to distinguish the fact that the company, the landowner, could not violate constitutional rights of free speech by excluding people from their property. But most of the other cases, unless you're in California, where the Pruneyard case was decided regarding shopping malls, you see that landowners can exclude. They can exclude even though it might violate somebody's constitutional rights. So here is what my proposal is, and this is the first time I've really presented it in this stark of a form, and I would love to get feedback either during question and answer or certainly afterwards during the day. Is in looking at all of these cases and trying to figure out when does state action apply such that you can make a constitutional argument, I think the way to look at this is not the state enforcing means that it is state action. I think that's much too broad, does away with the whole concept of state action. But I think if we look at it as state action when you are a individual, whether you're public or private individual, and you are suing a private individual, using as, basically I call it, using it as a sword to say, you private entity, you private individual are violating my constitutional rights. At that point, being a private actor, you cannot sue that private actor for a violation of your constitutional rights. However, if we take tort law, and particularly the speech torts that do involve the constitutional right, First Amendment right, if we look at that, you look at those cases, and that's where a defendant is using their constitutional rights as a shield against that action being brought. So when it's used as a shield, such as in Snyder versus Phelps or New York Times versus Sullivan, then at that point, you can, even if you are a private individual and it is a private cause of action, you can assert your constitutional rights as a shield against that action. So that's going to change some laws. It's not going to change anything, I don't think, in the tort area, although I have tort experts all around me. But it would change things in some of the contract areas and the property areas, so that you could have a trespass suit where the individual who is trespassing can defend based upon their constitutional rights. Same thing with homeowner association rules. And when you look at nuisance, I would say the same thing with nuisance. And where it comes up in nuisance law is really only when you have the private parties bringing a public nuisance or even a private nuisance. But it's got to be a private party, because as soon as you have the government official bringing a public nuisance action, then of course there's state action involved there. So this has been the area that I've been pondering for a while, and this is what I've come up with as a way to understand how state action has been applied in the past and how it should be applied in the future. So again, I'd appreciate any helpful comments you can tell, and from my colleagues up here, you can tell me if I'm totally crazy, that's okay. Thank you.
Thank you, Professor Saxer. And now we will turn to Mr. Schwartz.
Hey, thank you.
Thank you.
And thank all of you. These forums are just the greatest for me. I always learn more than whatever I provide. And I was thinking last night, how did it all start? I do want to mention Donald Cochin, who, because this organization, because of COVID and other things, was going a little downhill, and he's got it at the top of the mountain. Just look at the program today. Well, how did it start? There was a judge on the Supreme Court of Nebraska named Harry Spencer, and I was 33 years old, and he called me up and he said, do you want to do judicial education? Well, I was scared out of my mind. You're young, and I know the judges are so smart, and he said, well, just be yourself. Harry Spencer, I looked up last night, lived to be 104 years old. All that time worrying about original sin, and here I am. It just the casebook is Prosser, Wade, and Schwartz. Dean Wade was dean of Vanderbilt Law School, and he was a great teacher of mine. And the book is sort of well known, and I was interviewing White House fellows. I had some minor job in one of these administrations. So I'd ask them what casebook they used. Most of them had no clue. And then one guy came in and he said, I remember it was a blue book with a red insert. I was so excited. I said, wow, do you remember the authors? He said, I sure do. Prosser, Wade, and some other guy. So humility is a good thing. We all need it. The law of public nuisance has been, and the reason we're really here, is that some very enterprising plaintiffs' lawyers have tried to change it. Most judges have said, I'm not so sure about the change. because tort law, as anybody who picks up a case law knows, is in boxes. If you don't touch somebody, it's not a battery. If you don't put somebody in apprehension of fear, it's not an assault. So that's why there are chapters. And nuisance does have some malleability. As an earlier speaker, Professor Bublick said, there's private nuisance, public nuisance. I see public nuisance as interfering with public ways. Private nuisance, it's your own backyard, and somebody is trying to mess it up. But public nuisance is the one that both privately and some attorney generals, and to the attorney general staff here, I've got to know the Attorney General Alliance, and it's a great thing with David Blake. We talked about the liability for COVID. So you have an important job in thinking about whether you want to bring private nuisance actions. Plaintiffs' lawyers sort of see the public nuisance as what I would call the schmoo of the 24th century. Let me explain. Many years ago, there was a very enterprising cartoonist named L.L.P. Does anybody remember him? A few people here are over 100. So he had this creature called the schmoo, and it was white, and it would change into whatever food you wanted. So if you wanted a hamburger, the schmoo became a hamburger. If you wanted an ice cream cone, that's what it became. Well, I see the efforts of some enterprising plaintiffs' lawyers as trying to turn the law of public nuisance into the schmoo of the 21st century. So it becomes what they want. But there are some elements to it, and I'll just mention a few because the restatement of torts third is going to address private nuisance. It already has a draft out, and I'd commend you to look at it. A professor named John Goldberg from Harvard wrote it. I thought he did a very good job, very thoughtful, but they're unlikely to touch public nuisance. Prosser did, and he heard from everybody in the world, but he sort of stuck to some of the basics. And the basics include this. It's an interference with a public right, and other speakers have said this. A highway, a river, not something that's of your own use, your own backyard, where smoke comes in. And this one, I would say, is missed by a few courts, but certainly change is wanted. And that is, public nuisance deals with an activity, dumping something in a river, blocking a roadway. That is an activity. But enterprising plaintiffs' lawyers are trying to make the manufacture of a product an activity. Why? So if you make a firearm, if you make a car that goes over 100 miles an hour and somebody's killed, they're trying to turn that into a public nuisance. But that's not an activity. That's product liability. And remember the boxes. That's a restatement of product liability done by Aaron Chorsky, so it was blessed. It is a good book, and it covers all product liability actions. And to try to skirt product liability laws by the law of nuisance, I think, just defies the fundamentals of tort law. And it's got to be a wrongful activity. And an earlier speaker adverted to that. That it has to be something where the harm from it outweighs the good. So if somebody is suing all the oil companies or energy companies for public nuisance, and you ignore what is needed for gas, prices going up, oil, heating, you're not really following the law of public nuisance, because the faults of the product, the harm of the product, should outweigh the benefits of whatever the product is. And then there's an element called control. Public nuisance works toward injunctions to stop something. Well, how logically do you stop something if somebody no longer controls it? If they sell a product to a third party, and the third party takes that product and dumps it in a river, the original seller, who may not know the person or where he is or she is using the product, has no control. Some courts have dropped this element, and I mentioned it in my paper. And by the way, the paper is there. I always like to have a paper because people forget, and I kept it under 10 pages because they want stuff short. I call my articles pot articles, not the dope. You can read it while on the pot. That's what the idea is. So that, I think, fulfills that missive that's on your plate. So control is important. And finally, so there's only 5 elements. It's causation. So if Ford sells a car that goes 105 miles an hour and a driver drives 105 miles an hour, is drunk, the intervening acts of the person who drove is an impediment for the tort to begin. All 5 elements are in my paper. Tort law changes, I sure know that. Science changes. 60 years ago, if a child was injured in the womb, he or she could not have a cause of action. When we learned that the child could be viable, the science showed how the injury could occur, tort law changed to accommodate that. But just changing the tort law to help create a cause of action, to me, is not where tort should be. And public nuisance should not be the schmoo of the 21st century. Thank you all very much.
Thank you. And now we'll hear from Professor Sharkey.
There we go. Great. Thank you very much. I also want to thank Donald and the whole team. It's a real pleasure to be here. I'm not as wise and old as the moon as Victor, but I've also been privileged throughout my career to speak with judges, and today we've got people from the Attorney General's office as well, and it's one of my favorite things to do, so that's what brings me here. The second thing is I too have a torts casebook. I joined Richard Epstein, my co-author, and it's just as a historical note, it's a phenomenon, right, that if you trace treatises and casebooks, there was more attention given to public nuisance historically earlier. Then it was a little bit sort of forgotten, and now there is a kind of burst on the scene. And it's an interesting phenomenon to think about. I commend, and I agree wholeheartedly when Victor says, and the thrust, I haven't read the paper, I was skimming it, although I was trying to focus on the talk here. I really do believe that there needs to be some attention to the elements of the tort. And so as Professor Bublick began today, and I want to continue, I'm particularly interested in beginning with what is this tort of private public nuisance. As she mentioned at an earlier conference where we were, there were competing arguments. This isn't a tort. It just came in as part of either the law of the shmoo. I mean, Victor alluded to its historical roots, but what is this? And I think as a torts professor, it's worthwhile to go back and look at it. But my own interest came actually through data breach cases and other economic harm cases. I have several articles where I was looking specifically within the realm of tort about what happens when people allege harms that don't involve physical or property damage, but purely financial losses. So that's where I was looking at these data breach cases. And there's something called the economic loss rule that it's in its strong form posits that you don't get tort recovery for negligent conduct that leads to exclusively financial losses. Now, lo and behold, an interesting phenomenon is the Torts Restatement Third on liability for economic harm, which posits this economic loss rule, has a kind of escape valve. It has a section in it on public nuisance that says you can go forward as long as you meet the elements of public nuisance and bring your cases there. So if anything, that third restatement, I think, incentivizes parties who might be facing an economic loss barrier to try to restructure their claims as public nuisance, and almost no attention is given to these economic harm private cases. There are people like my friend and co-author Richard Epstein who claim that historically no action in private public nuisance was brought for economic injury. And there are others who say, well, look, the third restatement suggests that this is a viable route. As Victor alluded to, we've got a very malleable standard in the second restatement on tort on what private public nuisance is. And so the third restatement, by giving this escape valve, but not really elaborating on the elements, has created, I think, kind of like the perfect storm. And it's the perfect storm for a law professor to come in and try to think through what are these elements, what's the function that's being served by these private public nuisance action. So just very quickly, the sort of canonical case in the economic loss rule, 532 Madison Avenue, there was negligence that led to a building collapsing, and then a deli that was nearby lost all of its customers and sued both in negligence for purely financial losses and in public nuisance. So actually, one of the interesting things to trace historically is how often negligence and public nuisance were brought hand in hand, and when that sort of happened historically, that phenomenon. But what the court said, the New York Court of Appeals, and this is sort of the classic elaboration of the economic loss rule, is they were worried that you would, if you allowed recovery for these purely financial losses, you would have unlimited liability to an indeterminate class of persons. So this worry about, well, in tort, we want to have the right amount of liability, but we don't want to have disproportionate, unlimited liability, has led many courts to sort of cut off recovery and say you can recover for physical or property damage, but not for economic losses. Now, what I was really interested, having steeped myself in the economic loss rule, is then when I come over to the private public nuisance action, as Professor Bublick mentioned in her talk, there's a very strong requirement of special injury. And what does it mean? Why can a private party bring an action for an invasion of a public right? What's going on there? They have to have suffered special injury, which has been elaborated by courts as meaning different in kind, not simply degree. I have a fisherman here. It doesn't look like a commercial fisherman. Imagine a commercial fisherman, because you can read all the cases, and whether they're in the economic loss rule camp or public nuisance, fishermen have this privileged status. Like, a lot of times they recover. And some people even said, like, Admiralty loves is a favorite in tort law, so the commercial fisherman should be privileged. To me, that's not a very satisfying explanation, right? Why can the commercial fisherman recover, but a business, right, that's right there on the coast and loses everything? Sometimes the courts say, well, the fishermen depend on their livelihood. Well, so does this business that doesn't recover. Or the fisherman's the stand-in for the fish, but maybe the person on the, the business right at the water that gathers people who do water activities as a stand-in for the pristine water. So none of those rationales, to me, are very satisfying. And a deep dive into the case law just shows a lot of disarray. It shows that sometimes it matters. If a plaintiff in a particular jurisdiction brings the claim as negligence, they will recover and get around the economic loss rule in a kind of exception. Sometimes they will not, but if they bring it as public nuisance, they will recover. So to me, that's puzzling. We should actually have a coherence in the law, and these things, they should rise or fall, forgive the pun, in the sense of some of these public nuisance cases together. So private public nuisance goes way back. This is 1536 in the anonymous case. And I think this case is not only interesting to show the historical roots, but it phenomenally, I think, captures what's going on between public and private enforcement in the tort of public nuisance. So the idea here is that if there's a blockage here on the King's Highway, right, we're going to leave that to the LEAT. That's the administrative body that's going to be the one that's going to deal with this harm, because it affects everyone in the community, and that's what we're going to have public enforcement for. But if someone has, quote, greater hurt or inconvenience, more inconvenience than the generality, then they're going to be able to bring an action for damage. And so I strongly, and my co-author Richard Epstein strongly and emphatically rejects too, that somehow public and private nuisance are wholly distinct. Sometimes you hear people say public nuisance is really just like a crime and it's totally unconnected to private nuisance. If you go back to the historical cases, there are lots of instances where public and private nuisance are brought hand in hand, and there's a lot of talk about enforcement. Which kinds of things do we want to leave to a kind of public enforcer, and which kind of things, usually where there are concentrated losses on particular parties, we in tort law allow them to come forward with the tort of private public nuisance. This is a quote from Blackstone again that worries about why don't we allow everyone to come forward with their private public nuisance. He says because it would be, quote, unreasonable to multiply suits by giving every man a separate right of action. There's definitely a distinct worry in the historical cases about multiplicity of actions, right? You don't want every private individual in the entire community, all of whom have suffered, some small, or usually in their mind they're thinking some small widespread harm. You don't want every individual coming forward. By the way, this is pre-class action, right? So all the courts are thinking about, we don't want to sort of have all this rush to the courtroom, this multiplicity of action. But implicit in that, in my mind at least, is is a move away. I'll put it this way. You see in some courts, and here's one example, that courts will defend the special injury. Why do we want to only sort of have the person with concentrated special injury come forward? You see courts rear this unlimited liability fear, the exact same one, by the way, that you see in the cases about the economic loss rule, right? So here's just one example that if you didn't have this special harm requirement, it says here that it's clear that the special harm requirement serves the same purpose as the economic loss doctrine, to limit liability arising from an event. Otherwise, liability could be exorbitant. Well, that's true, but that's not really a principle, to my mind. That's not a good principle unless you just want to cut off, right? You hate tort law, you think it never should come forward. It's a very nice, bright line rule, right? I sometimes jive. Richard Epstein has a great book, Simple Rules for a Complex World. That's too simple in my mind. And if you go back historically, that's not how courts were thinking, and they weren't just saying we have to just cut things off because otherwise we're going to have unlimited liability. Over-deterrence is a problem. We have to worry about that, but courts also worry about dramatic under-deterrence, right? If you don't deputize someone to come forward to enforce where there's been real harm, then you should be worried about that side of the ledger as well. So what I want to do, and I wrote an earlier article, not called Public Nuisance as Law of the Shmoo. Maybe I'll write, that'll be maybe my next one. But the one that I wrote was Public Nuisance as modern business tort. And again, it started with a principle that I think even Victor would be behind, that there seems something bizarre with the third restatement liability on economic harm, shoehorning cases by saying you can't bring them in negligence, go ahead and bring your economic harm cases through public nuisance. That to me doesn't seem like the right way to go. To me, it seems more principled to step back and say, whether you bring your claim in negligence or private public nuisance, what are the relevant elements? What does it mean, right? What's the enduring principle from early cases about what special injury means and where we need private enforcement in addition to or instead of public enforcement? So my thought in this realm is that both in the realm of negligence with economic loss rule and private public nuisance, that we should think not about limitations of liability as being our principle, but a kind of principle of channeling or an enforcement rationale. Namely, you're going to deputize a smaller class of sort of, we can call them the first tier victims, we can call them the significantly impacted individuals and entities that are affected. And it can be physical injury, it can be emotional, it can be economic. There's no distinction where you would just draw a kind of bright line rule. The historical perspective, it turns out, as Professor Bublick mentioned, we thought we'd take on a kind of like public service as academic role stemming from the last conference of just amassing this data set of historical cases for everyone because people were making claims about what the cases said. And they hadn't read the cases, and it's understandable. If you go and look at the legal literature, there's not a lot. There's some quick word search surveys done or people cherry picking certain cases. So we're in this process, but I've cherry picked a few because to me they seem to personify kind of this channeling deterrence rationale. So this one's from Queen Bench 1599. A defendant had obstructed a watering place used by all of the residents, and in there's a discussion about how there's no other remedy available, that there's not going to be public enforcement, and so therefore we need to have a private actor come forward. They say, quote, if the public cannot avenge or restrain the nuisance, every citizen must be permitted to recover. Here's another one from the Ohio Supreme Court in 1831. This one was really interesting. It talked about if a man were to sally forth into the public streets of a town and commit an assault and battery on every person he met, we wouldn't say as a defense, oh, he didn't just beat the plaintiff, but also beat up the whole town, right? So this idea about what's going on, right? We need to have some balancing with regard to who can or can't come forward. And the idea that you can do sort of serious injury to groups of people and then use this to get away was not satisfactory. Okay, very quickly, because I see that I'm out of time. In the data breach area, you actually see, here's one example of a court that in my mind seemed to not just throw the case out saying, we might have unlimited liability, but attempted to do something close to this channeling rationale. Attempted to say that if we can have an identifiable class of plaintiffs, we're not going to have boundless liability, and therefore we'd be able to recognize certain types of harms. I'm not going to have time to go into this, unfortunately, in depth. Maybe in questions we can. In the opioids case, I think sometimes we forget, because most of those actions are being brought by state entities, that there are private individuals coming forward. In this case, there's some third-party payers and hospitals. There's an action that was brought by the West Boca Medical Center. And again, here, the channeling rationale wouldn't say, throw all of those out. You know, they're bringing economic losses, therefore they can't bring public nuisance. But it would attempt to really parse the different kinds of business injuries. And I'll cut forward to the punchline. I'll talk about two very quickly. So patients here, the hospital has brought forward one business injury about unreimbursed charges from the medical treatment of patients who have opioid conditions or conditions exacerbated by opioids. In my mind, I'll put a question mark, but arguably it seems that patients there could probably be adequate enforcers of those kinds of harms, that we wouldn't need, using this channeling rationale, we wouldn't need the hospitals to come forward to be the enforcers of those. If you're looking at that from an overall deterrence perspective, directly injured victims can vindicate the law as private attorney generals. It's the same with respect to increased costs as a result of purchasing opioid pills. Presumably, hospitals, even though arguably they might be the direct targets of sort of alleged misrepresentations, they pass these costs along to their patients, and maybe we don't need them to be primary enforcers. So where might we? There's this interesting idea of increased operational expenses, direct things that the hospitals had to pay to retrain their staff to be able to distinguish between pill seekers and people who really needed the medications, increased security, increased capital expenses for how they're housing these drugs and the like. And in this instance, I think channeling considerations, at least arguably, weigh in favor of liability, that there the hospitals are the first tier victims, and if those are actual concrete losses, no one else is going to enforce on behalf of them. So what I really care more about is not that you agree with my parsing, the question mark, the check, but the frame of analysis, that's the right kinds of questions to be asking and to be thinking through. Under special injury, do we need to channel a cause of action towards this entity who needs to come forward to enforce, because otherwise we're going to have an unenforced, unaddressed societal cost that should be internalized by the defendant. Thank you very much.
Thank you, Professor Sharkey. These were really great presentations to set the stage for what will hopefully be a lively discussion. Before turning to any specific questions, I want to give all the panelists just an opportunity to respond or react to any of the comments by their co-panelists. Okay, well, I will kick things off then. Since Professor Sharkey was the last to present, I do want to get the other panelists' reactions to this idea of channeling, and that may be the proper framework to think about what some perceive as the problems with public nuisance.
Let me jump in here. I really agree with it. I think it's very attractive. I wrote a book review of Professor Sharkey's article, and what I really like about it is this balance between incentivizing entities to take care and also, worrying about both over-deterrence and under-deterrence. And the way that I think about it in some ways is similar to the class action context and some of the questions where you have a significant claim on your own that you might bring by yourself. We say, hey, that can't be a part of a class action. Bring that case. You bring that claim. If I have a personal injury, I'm not going to bundle it with everyone else's personal injuries. But then sometimes where we have small injuries in common, we would say that's appropriate for class action, that's appropriate for some kind of public enforcement. And when I think about, what are the attorney generals doing in terms of protecting rights, you're looking at, I think, a lot of the impacts of opioids, for example, on the whole society to the extent that you can bring those claims. But a particular individual who has special injury, that special injury rule is suggesting that, maybe the best representative of somebody who really has a significant injury is that individual, him or herself, as opposed to, you know, some generalized action.
I'm trying to figure out, how does this relate to the idea of a private attorney general, or is that what you're looking for? And is it like the class action, but then we pile on top of that the requirements for class action, right? That this is a representative, and so I'm not sure where it fits in.
Yeah,
in
so
those areas.
I'll just say very briefly, it's a great question, and one of the you know, I did, the first thing is, as a law professor, right, is you kind of have this insight. My insight, I think, was merging these doctrinal lines dealing with negligence and public nuisance with the economic loss rule and special injury. But then once you get wed to your own insight or theory, you have to then start figuring out how this would work out. And it's a great question, and I have to say honestly, I haven't quite figured it out entirely. And part of the, Professor Bublick alluded to, there are a couple reasons why we wanted to amass this historical data set and look over time, because I have some theories, but they're not backed yet by any empirical evidence. In a sense, that's kind of what law professors do, but probably less relevant to the audience that we have here. But there's a very intricate, my theory is there's a very intricate interrelationship between tort law and public regulation, and what happens, for example, with a burgeoning administrative state, and what happens with things like public nuisance. Private public nuisance actions used to be, I think, much more of a strong thing about how we had these private attorney generals, right, enforcing against pollution, et cetera. Once you get the EPA and the Clean Air Act and the Clean Water Act, then you might be into a situation where you have to ask yourself the question, do you need both? So what I will do, just one quick footnote, is I've looked at this very much in the economic losses realm. I was puzzled by why historically, right, you could always bring an action in both tort and contract against an attorney. And even the third restatement, liability for economic harms, which says no liability for these purely economic losses between contracting parties, has a carve out for quote unquote professionals. And then everyone's arguing who's a professional. But everyone agrees lawyers are professionals. So no matter how strong your economic loss rule is, you can always bring a tort action. And I looked at that historically, and when I started reading the cases, it became very clear tort was a mechanism before we had regulations on attorneys of how to police certain contracting parties like lawyers who were supposed to be representing the public, not just their private client. And it led me to ask the question, fast forward to the modern age, like, do we still need that? Might we have other means where we're regulating these entities? So the exact way where the class action will fit in, or this idea of when you have special injury, do you also in the modern context need to sort of show that you have representational creds, is a really fascinating question that's to come in writing.
I want to read more about channeling. I hadn't heard the term. There are, I think, 40 attorney general's offices here, and the attorney generals I've been impressed with, and when it comes to a public nuisance that meets the elements of public nuisances I've outlined, their responsibility is one that they often meet. They have their organization. So private actions are a supplement, and that's why they have the rule that there has to be a special harm to an individual that's different in kind. So I would keep that, and the elements that are set forth, the 5 elements. But public nuisance, private auxiliary should be limited to situations where somebody really has been harmed differently. So if it's a highway's blocked and you're delayed because you don't get an appointment, that's not private action. But if somehow there's a gut in the road and your car is damaged and nobody else's is, that's in the mainstream. So I want to read more about channeling. I've not heard that term, and it's always good to have new terms, and tort law moves on, but I wouldn't change the fundamentals of the tort.
Thank you. We have a number of questions from the audience, so we'll go ahead and turn to those now. We've got a couple of questions, I think, that are related to one another. about the role of the common law. So if the common law, if the primary intrinsic quality of the common law is that it changes and adapts to societal problems, why shouldn't it, in the case of public nuisance as well? And then I think a related question here is, if that's our model, then what limiting principles can we place on that?
I mean, let me add here. I mean, I think the common law changes, but it always does so in sort of an incremental way. I don't see judges saying, you know, we have hundreds of years of cases and today, let's get rid of them. So I think, you know, Professor Sharkey's comment about, you know, maybe we don't need lawyer malpractice suits anymore the way we did because now we have regulators. Well, for those individuals who have a special injury, like, you know, the lawyer's breach of fiduciary duty costs them $500,000, that's a special injury, we're still going to have an action. And I think, you know, here, the common law, when it's changing, the question is, why did we need that tort for all those years? And if we need it more, or if we need it less, then it can probably change in the kinds of incremental ways that it always has been to meet those functions. And it's not just that, you know, I decide today, like, I don't like this tort anymore. Part of what got me interested in reading all these cases is that at one point, one of the restatement reporters was saying, let's get rid of private actions for public nuisance. We don't need them anymore. And I thought to myself, well, if we get rid of this tort, what are we getting rid of? Like, before we cut off the arm, let's just see, you know, what is it? What are we cutting? And so going back into the cases and seeing that there have been so many makes me think, it must be serving some function that we've had it for all this time. So to me, you know, to say, well, the common law can change and we don't really want this tort anymore, get rid of it, isn't really an appropriate role for common law bodies. Might be fine for a legislature or someone like that to make extreme changes, but I don't think it's the role of either the restatement, which is designed to reflect the law, or of judges who are working in that process.
I'll be brief, because I've thought a lot about it. Everybody here about the change in tort law. If there is an element of a tort which no longer meets science, so for a period of time, emotional harm wasn't recognized, but then it was scientifically recognized as a harm, that's a reason for a change. So that's good apples. The bad apples are changing tort because you can't fit into the tort that's designed for that purpose, such as product liability and proving defect. So if you're suing a firearms manufacturer, was the firearm defective? Or do you want to avoid that and call a sale a public nuisance? I don't agree with that because it's not an activity to have a sale. So the judges here think about this. Is the reason for the rule still valid? If it is, don't change it. If it isn't because of newly discovered things, change may be appropriate. But if the change is just to get around another tort, there was an attempt in the restatement, still there somewhat, to change the law of battery, which has been the same for a long time, to make it into a subjective tort. So if I don't like to be touched by a feather, then I say I don't like that, and that's a battery. That's just going to lead to a bunch of nonsense. And that's a change that is not backed by reason.
I would say, so I'll try to be brief too, because I mean, it's a great question, and I am writing a few articles about this at the moment. So I'll say succinctly, think about, Victor mentions products liability, right? Look at that historically in the evolution. That was wholly in contract with a privity limitation, no tort for a long time. Then there was a revolution. There were lots of reasons why courts decided that we would move these kinds of harms from contract into tort. First, it was done into negligence, then it was done into strict liability. One of the underlying enduring principles, I would say, is a kind of deterrence-based focus, that there was an idea that this kind of liability rule would morph and change because we wanted to prevent very high rising kinds of costs from products and the like. So to my mind, it's hard to specify how these things should come in doctrinally. What I'm trying to do here through this effort of defining kind of a real limitation with regard to special injury through the channeling deterrence rationale is to suggest that that could be reason for both cutting off liability but also expanding it. That's sort of one way. We have many historical examples. The quick point that I'd make, which is something that might be of interest and I'm fascinated and would love to talk to the judges about, is I have worries about what's happening to the common law evolution of torts in this area and many others. And the worry is that there are various doctrinal moves. I'll be controversial and I'll say one of them. Whether you like the global warming public nuisance tort or not, what the Second Circuit did by reading a complaint to be not a state public nuisance tort, but a federal common law tort, and then saying that's displaced by our federal displacement, is a move that I'm strongly critical of. I don't think that doctrines like federal displacement, preemption, primary jurisdiction is swirling around in a lot of the COVID public nuisance cases. It's very easy to use those doctrines if you just want to get the thing gone. But what does that do? It doesn't lead to any kind of state law focus on, or federal law sitting in diversity, federal court sitting in diversity, thinking about what should the elements of this tort be. You see it in the opioids cases. You see some courts saying, yes, it's public nuisance, some no. You see very little delving into what are the elements, what do they mean, what did this mean historically. So that's my worry. I think we can do it so long as we don't have these doctrinal blocks that are going to stymie the evolution. And I think products liability and its evolution over a long period of time, as Professor Bublick was mentioning, with incremental change to sort of react, in my mind, very strongly towards a kind of prevention mode. But my view of modern tort theory is that it should be very much about preventing harms, a lot less about recognizing distinct wrong, quote unquote, wrongs done to individuals, but preventing harms. And I think that's what we're going to see if we allow for the elaboration of this tort. And more people should be thinking about it, and more people should be reading, frankly, more people should be reading this corpus. We'd welcome, others into the project of reading thousands of cases and trying to distill, because while I agree with Victor that we need to specify the elements, it's not quite clear. For example, causation, I'll just mention one. I fully agree that we should sort of have a coherent notion of causation, but if you go and trace this historically, there's a lot of difference. Like, do public entities have to show causation in the same way a private enforcer would? Why? Why would the causation requirements be higher or more stringent on the private? There's a lot of work to be done that frankly people aren't doing at the moment.
Well, and can I give a different invitation, and that is sometimes when you have cases for the judges that you've decided and you think, this was a tough case, an interesting case, an important case, I think it's important for us as academics to magnify your voices on some of the great common law decisions that you're writing. We have a colleague, John Goldberg at Harvard, who sort of wrote a piece saying, who are the state court judges who are living up to Cardozo? Well, I mean, we can't live up to, some of the, Dean Prossers and stuff like that. So it's sort of like but I think the point that he was making, I said to him, I think one of the problems is you're not reading enough judges, you're not reading enough cases, because there's so many great decisions out there. And when you have decisions that you write in the torts field that you think you've really, nailed that concept, you're really, building the common law, then, reach back out to us and to other academics too, so that we can share some of that work more widely.
I think we have time for one more question. So I do want to talk a little bit about what efforts there have been to address this gap, to the extent there is one, in kind of historically, whether tort law provides a cause of action for these sorts of harms, what efforts there have been to address that legislatively, and whether that is a viable alternative to the common law evolving to address these issues.
Let me just add one quick thing on the legislation. I can't believe there aren't more civil RICO claims in a lot of these cases. Like for the public actions by the attorney generals, I don't know if you're looking into civil RICO claims. I see them a little bit, but I think that statutory action seems to me like it could be applicable in a lot of these cases where people are claiming fraud. So I know people are using a lot of statutes, but I think that's one that it seems to me addresses the public nuisance issue, at least potentially overlaps with the public nuisance issue.
When states have enacted laws, for example, Oklahoma purportedly changed the law of nuisance, but it was so ambiguous that it could confuse courts. There's no legislative history, as there may be with Congress. So often when legislatures have stepped into the nuisance barrel, they've produced something that creates more litigation.
Yeah, I was just going to say, this dovetails with what Victor just said. As an empirical matter, it's breathtaking, actually, how many they are really early, they're 19th century statutes. Most jurisdictions have nuisance statutes with breathtakingly broad articulation of the public right. So there are some who claim that the public right should just be what's historical, like blocking bridges and public waterways. That's clearly false historically, even without looking at these statutes, right? Professor Bublick was mentioning some of the House of Ill fame. There's lots of those cases. There's others that involve economic harm. But what is also in need of some elaboration, and this came up at the previous conference, is when you look, Oklahoma is one example, but it's not alone. You have these breathtakingly broad articulation that the invasion of the public right is anything that causes offense or a noise. So it's like the legislature it's an area that early on the legislatures had come up with these very, very broad articulation. And it's an interesting question to think about, in modern sort of interventions, if something could be done in that sphere to sort of tamp down on what's the proper sphere for the public right. But today, unfortunately, we have, people, I think, just making claims at two extremes. On the one hand, a public right is nothing except something very closely akin to a land-based private nuisance interference. And on the other, following some of these early statutes, it's like anything, like your presence is annoying me at the moment, and therefore it's a violation of a public right. So we need one or the other. I mean, we need work to be done. I think looking at this corpus of cases is probably a more fruitful endeavor than thinking about sort of educating legislatures to intervene, but maybe that could come after a while.
I would add, just from the state action standpoint, that I have seen cases where if the tort has been put into statute, that it's on that basis that state action is found, because we now have a statute instead of common law, which to me, it should be the same, whether it's tort common law or statutory tort.
All right, we may actually have time for one more question. So there is an audience question about how entities are supposed to predict their liability, whether evolution is occurring through the common law or through, interpretation of really broad statutes. Is this a problem for business entities in determining what their liability may be?
I think it is. I mean, we, pharmaceutical area, auto area, the laws in any particular state can change by common law more frequently than they used to. I've had many clients say, Victor, almost I don't care what the rule is, but I need to know what the rule is. And I think that is a problem.
I would say if you look at how nuisance was used previously, before we had all of our environmental statutes coming in, those manufacturers, polluters, they would have problems trying to understand where's my liability here. So I don't know, I think it does need to change to allow the public to be able to address some of these harms that are not being reached by legislation for whatever reason.
I guess I would say to a business, a lot of the specifics are going to change, but the enduring pieces of tort law are wrongfulness causing harm. And to the extent that you find that you can conduct yourself in a way that is appropriate, that is reasonable, and that you can avoid harms to others, do that. And if you can't, there's nothing more you can do anyway. And if you focus on those principles of just trying to avoid wrongfully caused harm, that hopefully whatever particular iterations there are in the rules, you'll be doing well.
So the question prompts me to think about data breach, and I'll be very brief, but the idea, I sat in a conference once where I overheard those who were worried about potential liability in data breach. And if you looked out into the world, there were lots of cases that said no liability for economic harm, so you're scot-free. But there were others. There was the Home Depot case in Georgia, and there was another where there was a breathtakingly broad articulation of you owe a duty to the world for reasonable security, right? So I thought to myself, okay, imagine yourself in the real world, like what is that liability risk? How are you going to protect against it? And what it dawned on me is there's a kind of, for burgeoning field, so data breach I would say is one of them, there's a little bit of a chicken and egg. Like I think it's wrong advice to tell those people that you face no legal liability, don't worry, we have the economic loss rule. And as soon as they start fearing that there's some liability, then the insurance market kicks in. So in data breach, there'd been a lot of first-party insurance for when you had your own losses, but not third-party liability insurance. Well, that market starts to develop, and then what happens? Those insurers are very interested in risk minimization tactics. So they come up with more factors, like what does reasonable security mean? They say you have to do these 12 things. And to my mind, that's a good story, right? But it's not a comforting story to tell a defendant sort of at the precipice of like a burgeoning new kind of field or articulation of liability. But tort law isn't the thing to be feared in that story, because the liability will then lead to the development of the insurance market, and if the insurance market is doing this risk minimization, they can come up with more specified features. And the same thing, in data breach, there are all these industry standards about protecting credit cards and the like, and things like that. So part of it is tort law might not be good at articulating, what are the 10 things that we need to be reasonably secure. But once the worst scenario in my mind is saying there's no liability, let's immunize them, let's protect them when we have real harms, because then there's no incentive for the insurance market, there's no incentive for anyone to be focused on what are those risk minimizing, harm preventing measures. But again, it's not really easy to sort of give advice apart from you're going to face some liability, so you better start thinking about this. And the insurance market, as I said, we have a lot of historical examples where we could look to and say we would have the same fear, same thing as the beginning of products liability, right? And it's worked out, reasonably well.
Join me.
I'll be very quick. All elements, at least in my world, of tort law have been dismissed. Medical monitoring cases where there's no harm. Causation where an expert testifies who's not qualified and the jury makes the leap on causation. And there's an article cited in my paper about deep pocket jurisprudence. It gives a whole bunch of situations where the person who did the wrong doesn't have any money, so they blame somebody else.
Please join me in thanking all of our panelists. This has been a really wonderful discussion.